A landlord may sometimes find themselves with a very difficult tenant who is refusing to allow access to the let premises. Access is often required for the purposes of carrying out a routine inspection of the condition of the property, to carry out routine maintenance or even repairs. There are many problems that can arise where a tenant fails to allow access to a property. Just some of those include compromising the health and safety of the occupants of the property, damage to the property, and even restrictions on eviction where the landlord needs to obtain a new valid energy performance certificate or gas safety certificate in order to serve the tenant with a no-fault notice, being the Section 21 notice. The question that therefore arises is what should or can a landlord do in respect of a tenant who is not allowing access to the let premises? The first things to note is that a tenant does have the right to quiet enjoyment of the property. That means they do have the right to reside in the property without interference of the landlord. This is a right that's implied by law, so it doesn't matter if the tenancy does or does not state that the tenant has that right, because it is a right that's implied by law. The tenant generally also has a right to exclusive possession of the property, which is also the right to exclude everybody else, including the landlord, from the property. However, it's also implied by law that a tenant must give the landlord or anybody acting on the landlord's behalf access to the property upon being given at least 24 hours written notice. Now, in addition to giving the tenant at least 24 hours written notification that access is required, the tenant should be given the date and, where possible, the time that access is required, as well as the reason that access is required. Now, where a tenant states the date and time proposed is perhaps inconvenient for them, the landlord should always work with the tenant to try and agree on a more convenient date and time. Here, the focus is very much upon those situations where the landlord has used all reasonable attempts to gain access to the property, but the tenant is not cooperating and is persistently refusing access. In those situations, legal action will probably need to be taken. The first step for the landlord will be to serve the tenant with a letter before action. In this case, this is a letter which would set out the background to the matter, the rights and obligations of both the landlord and of the tenant in relation to access of the property, and it would also crucially set out that unless the tenant does allow access to the property within a specified period, that the landlord may apply to the court to seek an injunction against the tenant, along with an order that the tenant pays the landlord's legal costs. The application to seek an injunction in these circumstances is a civil application. Generally, the application would be made to the county court. And that's because the tenant is not committing a criminal offence by refusing the landlord or anybody who acts on the landlord's behalf access to the let property. The injunction is sometimes referred to as an order for specific performance, because the court is being asked to order the tenant to perform their specific legal obligations, which in this case would be an order that they allow access to the property for a specific reason or purpose. An injunction would normally have something called a penal notice contained within it, and this is notification to the tenant against whom the injunction is made that if they disobey the order of the court, they could be guilty of contempt of court, and that is a serious criminal offence. If a tenant does breach the terms of an injunction, the landlord could apply to the court for committal proceedings to take place. And that's a process in which the court would firstly decide whether the tenant is guilty of contempt of court, and if they are, they would then decide what punishment would be appropriate. That could be anything from imprisonment to a fine or any other punishment permitted by law. It's quite unlikely that a landlord will find themselves in a situation where they're having to consider making an application for committal proceedings to take place. We generally do find that step one resolves the problem. Once the tenant has been served with a letter before action, and the tenant then understands the consequences of not allowing access to the property, that generally does seem to resolve the problem. But in some cases, further action can be required. So if you do have a tenant who is refusing access to the property, do contact our legal team and we will be able to assist you with that.
Landlord Advice UK, serving your legal needs.